Hi everyone. In this video, we will continue discussing the different kinds of obligations. The last time, we classified obligations into two general classifications. 1. The primary classification, and 2. The secondary classifications of obligations. We also gave a definition for each of the kinds of conditions under each general classification. But today, we will focus on the kinds of obligations under the primary classification, which include the following: pure, conditional, obligations with a period, alternative, facultative, joint, solidary, divisible, indivisible, obligations with a penal clause. Let us go to the first kind. Under Article 1179, it states that every obligation whose performance does not depend upon a future or uncertain event, or upon a past event unknown to the parties, is demandable at once. Every obligation which contains a resolutory condition shall also be demandable, without prejudice to the effects of the happening of the event. This article gives the concept of a pure obligation. A pure obligation is one whose performance does not depend upon any contingency and is immediately demandable. For example, Darla obligates herself to pay Cindy 10,000 pesos. There is no condition attached to the said obligation. It is immediately demandable. The second type is a conditional obligation, which is an obligation whose performance or delivery is based on a happening of an event. Its nature partakes of two types. 1. A past and unknown event, and 2. A future and uncertain event. We already gave an overview of the kinds of conditions in an earlier video. Check the link below. An obligation with a period is one whose consequences are subject in one way or another to the arrival of a day certain or a future but certain event. Note that, unlike a condition, which is a future and uncertain event, a period is one which is future and certain. In other words, a period is bound to happen. There might be uncertainty as to the exact time of the happening of the event, but it surely will come to pass. For example, getting a passing mark in a subject is a future and uncertain event, but dying is a future and certain event. Thus, passing a subject is a condition, but dying is a period. Under Article 1180, it states that, when the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. Note that, while having the means or the money to pay is a future and uncertain event, it becomes unfair to the creditor as there is no certainty if he will get paid or not. Thus, the law considers it as a period. As we said, a period is a future and certain event. It connotes a definite length of time. It is day certain. While having means or money to pay is a future and uncertain event, by express provision of law, such event is deemed a period. Note that under Article 1197, it is provided that, if the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period was intended, the court may fix the duration thereof. The court shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the court shall determine such period as may, under the circumstances, have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. The following are similar phrases which, by analogy, connotes a period. When I have the money. As soon as possible. When I can afford to pay. Little by little. Article 1181 states that in conditional obligations, the acquisition of rights, as well as the extinguishment or loss of those already acquired, shall depend upon the happening of the event which constitutes the condition. This article talks about the two kinds of conditional obligations. 1. The obligation with a suspensive condition, and 2. The obligation with a resolutory condition. In an obligation with suspensive condition, the obligation arises when the condition is fulfilled. For example, Maria binds herself to deliver an iPhone 10 to Linda if Linda gets a grade of 90 and above in all her subjects this semester. Getting a grade of 90 is a future and uncertain event. However, the moment Linda fulfills the condition and gets a grade of 90 and above in all her subjects this semester, then the obligation to give the iPhone 10 arises. Pending the fulfillment of the said condition, the obligation is suspended. In an obligation with a resolutory condition, the happening of the condition will extinguish an existing obligation. For example, Fred's parents will support his schooling until he graduates. There is an existing obligation to give support. This will continue until the condition is fulfilled, which is a future and uncertain event. Once the condition is fulfilled, that is, when Fred graduates from college, then the obligation to give support ends. Article 1182 provides that when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of the Civil Code. This article talks about the kinds of conditions as to source. Potestative, casual and mixed. A potestative condition is one which depends upon the will of one of the contracting parties. A potestative condition has two kinds. A condition that is potestative on the part of the debtor. For example, if I borrowed money from you and we agree that I will pay you if I feel I want to pay you. Note that in this case, both the obligation and the condition are void as the condition is fully dependent on the whims of the debtor. The second type is when the condition is potestative on the part of the creditor. For example, I borrowed money from you and we agreed that I will pay you when you want the payment already. A casual condition is one dependent upon chance or the will of a third person. For example, the condition agreed upon is, I will pay you if I win the lotto draw on Saturday, or I will contribute 10,000 pesos if my mother approves. In law, a third person is a stranger to a contract or one who is not a party to the agreement. Mixed condition is one which combines both potestative and casual conditions. For example, we agree that I will give you 100,000 pesos if your girlfriend agrees to marry you, and I win the lottery. Article 1183 states that impossible conditions, those contrary to good customs or public policy, and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. There are two types of impossible conditions. One is the physically impossible condition, and the other is the legally impossible condition. Physically impossible conditions are those which do not conform to the law of nature. For example, I will give you 10,000 pesos if you can bring the dead back to life. Legally impossible conditions are those contrary to law, morals, public policy, or public order. Example, I will give you 10,000 pesos if you can give me 1 kilo of prohibited drugs. What are the legal effects of impossible conditions? The general rule is that impossible conditions shall annul the obligations which depends upon them. Thus, both condition and obligation are voided. The exceptions are as follows. 1. Indivisible obligations. That part which is not affected by the impossible condition will not be affected. 2. If the condition is negative or not to do an impossible condition, it shall be considered as not having been agreed upon. Hence, the obligation is pure and valid. And 3. If the obligation is pre-existing and not dependent on the fulfillment of the impossible condition for its existence, only the condition is void. Article 1184 states that the condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. In an obligation with positive condition, the fulfillment of the condition involves the performance of an act. For example, in an obligation which it was agreed that I will give you 1,000 pesos if you graduate with honors. In order to be entitled to the 1,000 pesos, you have to ensure graduating with honors. However, if midway through your college schooling for your current course, you had failing marks in some of your subject, there is a showing that you will no longer graduate with honors, then the obligation to give you 1,000 pesos is now extinguished. Article 1185 states that the condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. Negative conditions involve the non-performance of an act. For example, I will give you 1,000 pesos if you will not have any failing grade. Article 1186 states that the condition shall be deemed fulfilled when the obliger voluntarily prevents its fulfillment. This article refers to the doctrine of constructive fulfillment of suspensive condition. It has the following requisites. 1. The condition is suspensive. 2. The debtor actually prevents the fulfillment of the condition. 3. The debtor acts voluntarily or willfully. For example, Daniela sold a parcel of land to Beto with a condition. The properties were mortgaged to Esther. It was agreed that Beto will likewise assume the mortgage, and upon payment of the mortgage loan, the certificate of title will be released to Beto. Later, Beto found out that Daniela paid the mortgage debt to Esther, and the certificate of title was issued to Daniela, and then sold the property to Carla. Since it was Daniela who prevented Beto from fulfilling the condition, it is deemed fulfilled. Article 1187 state that the effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interest during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interests received, unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. In obligations to do and not to do, the courts shall determine, in each case, the retroactive effect of the condition that has been complied with. The rule as to the retroactive effect of conditions are as follows. 1. In real obligation, once the condition is fulfilled, it shall retroact to the day of the constitution of the obligation. For example, on December 15th, 2019, Alma promised to give her car to Berta if the latter graduates in May 2020. Subsequently, Berta graduated in May 2020. By operation of law or ipso facto, as if Berta owned the car since December 15th, 2019. 2. In a personal obligation, the court shall determine the retroactive effect of the suspensive condition that was complied with. What about the effects of the fulfillment of a condition on the fruits and interests? The rules on the retroactive effect as to fruits and interests in real obligations are as follows. 1. In reciprocal obligations, there is no retroactive effect. The fruits and interests during the pendency of the condition shall be deemed to have been mutually compensated. 2. In unilateral obligation, there is no retroactive effect unless there is an agreement to the contrary. Article 1188 provides for the rights of the parties while waiting for the fulfillment of the condition. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. The rules on the loss, deterioration and improvement of a thing is governed by Article 1189. Article 1189 applies to a real obligation with a suspensive condition and the object is a specific thing, and the loss, deterioration or improvement of the thing occurs after the constitution of the obligation, but before the fulfillment of the condition. There are three kinds of loss: physical loss, legal loss, and civil loss. Physical loss occurs when the thing perishes like a house that is burned to ashes. Legal loss occurs when the thing goes out of commerce, like when the law prohibits it from being traded. Civil loss, which takes two forms: 1. When the thing disappears in such a way that its existence is unknown, like a car that was carnapped. 2. When the thing disappears in such a way that it cannot be recovered, like a diamond ring that was dropped in the middle of the ocean. Article 1189 has the following requisites. 1. The obligation is a real obligation. 2. The object is specific or determinate thing. 3. The obligation is subject to a suspensive condition. 4. The condition is fulfilled. And 5. There is loss, deterioration or improvement of the thing during the pendency of the condition. The rules on loss are: 1. If the thing lost without the fault of the debtor, the obligation is extinguished. 2. If the thing is lost through the fault of the debtor, he is liable for damages. The rules on deterioration are as follows. 1. If the thing deteriorates without the fault of the debtor, the impairment is borne by the creditor. 2. If the thing deteriorates through the fault of the debtor, the creditor may choose between rescission or cancellation of the obligation with indemnity for damages, or the fulfillment of the obligation, or specific performance with indemnity for damages. The rules on improvement are as follows. 1. If the thing is improved by nature or time, it benefits the creditor. 2. If the thing is improved at the expense of the debtor, he will have the rights of a usufructuary. Usufruct is a legal right accorded to a person or party that confers the temporary right to use and derive income or benefit from someone else's property. The usufructuary is the person who has the right to use the property of another. Article 1190 states that, when the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. In case of the loss, deterioration or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for the obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of the extinguishment of the obligation. Once a resolutory condition is fulfilled, the real obligation is extinguished and the parties have to give back what they received. In case of loss, deterioration or improvement, the rules in Article 1189 will apply. Article 1191. The power to rescind obligations is implied in reciprocal ones, in case one of the obligers should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation, with the payment of damages in either case. He may also seek rescission, even after he has chosen fulfillment, if the latter should become impossible. The court shall decree the rescission claimed, unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing in accordance with Articles 1385 and 1388 in the mortgage law. What is rescission? Rescission means undoing a contract from the beginning, and thus requires the return of the object of the contract. What are reciprocal obligations? Reciprocal obligations mean the obligations of the parties arise from the same agreement, each party being a debtor and creditor of each other, and the performance of one is conditioned on the simultaneous fulfillment of the other. The remedies in case of breach of reciprocal obligations include rescission or specific performance, with or without damages in either case. These remedies are alternative, and not cumulative, which means that the party so availing can only choose one remedy. The general rule in reciprocal obligations is that if one of the parties fails to comply with his obligation, the other party has the right to rescind. The exceptions include the following circumstances. 1. If there is waiver on the part of each party. 2. If the rescinding party cannot return what he has received or revert to status quo. Article 1192 states that, in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. In this case, the parties are in pari delicto. Article 1193 talks about obligations with a period. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Obligations with a resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. A period is a future and certain event. It is a day certain. It means that day or event will surely come, and which actual date may or may not be known. Unlike a condition where the uncertainty is on the happening of the event, in period the event will come to pass although there may be uncertainty as to the actual date of happening. For example, arrival of December 25th, 202 is a day certain. Another example of a certain and future event is dying as it is bound to happen, although the date it will happen is not known. A period has various classifications. As to effect, a period can be suspensive or resolutory. A suspensive period is one where the arrival of the period gives rise to the obligation. For example, Dana donates a parcel of land to Dinah to be delivered upon the death of Dana. A resolutory period is one where the arrival of the period ends an existing obligation. For example, by way of usufruct, Dinah allowed Dana to occupy her house until she dies. The kinds of period as to source are as follows. 1. The legal period. This is a period granted by law. For example, under Article 1391, which provides that the action for annulment shall be brought within 4 years. 2. Conventional or voluntary period. This is a period agreed upon by the parties. For example, Greg and Rami entered into a contract of loan for 100,000 pesos payable in 1 year. 3. The judicial period. This is a period fixed by the courts. For example, in a case for collection of money filed by Sally against Tony, the court rendered decision giving Tony a period of 90 days within which to tender full payment of all amounts due. As to definiteness, period is classified as follows. Definite period, as when the time and or date are known beforehand. For example, Holly binds herself to give Kyla a new pair of pants on her birthday. Indefinite period where the actual time date is not yet known. For example, Linda binds herself to donate all her property to a chosen charitable institution upon her death. Article 1194 provides that, in case of loss, deterioration or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. Article 1195 states that, anything paid or delivered before the arrival of the period, the obliger being unaware of the period or believing that the obligation has become due and demandable, may be recovered, with the fruits and interest. Thus, the rule on solutio indebiti or payment by mistake applies to a real obligation with a period. Any payment or delivery made before the arrival of the period is not yet demandable. Thus, the debtor can demand back its return. Article 1196 provides that, whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances it should appear that the period has been established in favor of one or of the other. As a general rule, whenever the parties agree on a period, it is presumed that that conventional period will benefit both of them. For example, Jenna borrowed the amount of 100,000 pesos from Willie, payable in a year, at an interest rate of 5% per month. In this example, Willie is benefited by the period because of the interest he will derive. Jenna is benefited as she can have that whole year to come up with the principal amount and in the meantime have an opportunity to earn from the use of that money. Article 1197 states that, if the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the court may fix the duration thereof. The court shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the court shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. In this case, the general rule is that the agreement of the parties as to period is controlling and the courts will not alter that period. The exceptions are: 1. If the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended. 2. If the period depends solely upon the will of the debtor. 3. If under the circumstances the parties have probably contemplated a period. And 4. When the debtor binds himself to pay when his means permit him to do so. We said earlier that under Article 1196, as a general rule, when the parties agree on a period, that is a conventional period which will benefit both parties. Article 1198 states the instances when the debtor loses the right to the period and the obligations becomes immediately due and demandable. 1. When after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debt. For example, in a contract of loan entered into on January 15, 2020, Tanya agreed to pay Yana 100,000 pesos on December 31, 2020. However, due to the COVID-19 pandemic, Tanya became insolvent on September 2020. In this case, Yana does not need to wait for December 31, 2020 and can immediately demand the obligation. 2. When he does not furnish to the creditor the guarantees or securities which he has promised. For example, in a contract of loan that will fall due on December 15, 2020, Tanya agreed to deliver her car to Yana on May 15, 2020 to secure payment of the obligation but failed to do so. Yana can immediately demand payment of the loan. 3. When by the debtor's own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. For example, in a contract of loan that will fall due on December 15, 2020, Tanya agreed to deliver her car to Yana on May 15, 2020 to secure payment of the obligation. Unfortunately, the car was stolen. Tanya was not able to give another property as security. Yana can immediately demand payment of the loan. 4. When the debtor violates any undertaking in consideration of which the creditor agreed to the period. For example, in a contract of loan with Yana that will fall due on December 15, 2020, Tanya agreed to use the money to pay her tuition fee on May 15, 2020. However, Tanya used the money in a gambling spree and lost. Yana can immediately demand payment of the loan. And 5. When the debtor attempts to abscond. To abscond means to escape. To attempt to escape shows bad faith as the debtor has displayed signs of evading his obligation. Article 1199 provides that, A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. There are various kinds of obligation as to subject, which are as follows. 1. Simple obligation. This is an obligation where there is only one subject. For example, Norley binds herself to deliver a horse to Sheila. 2. Compound obligation. This is an obligation where there are two or more subjects. For example, Viola binds herself to deliver a laptop, a mobile phone, and or an iPad to Rena, including all the accessories and accessions thereof. Compound obligations can either be conjunctive or distributive. A conjunctive obligation is one where all of the several objects must be performed or delivered for the obligation to be extinguished. A distributive obligation is a compound obligation where one of the several objects must be performed for the obligation to be extinguished. An alternative obligation is a kind of distributive obligation where the performance of any of the given obligations is sufficient. A facultative obligation is one where there is only one obligation but the debtor may substitute another object. Article 1200 provided that, in alternative obligations, the right of choice belongs to the debtor, unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. So, as a general rule, in alternative obligations, the right of choice belongs to the debtor. As an exception to the rule is when the right of choice has been expressly given to the creditor. The limitations on the choices of the debtor are as follows. 1. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. For example, Viola binds herself to deliver a laptop or a mobile phone or an iPad to Rena, including all the accessories and accessions thereof, or 100 grams of shabu. Viola can choose to deliver either one of the gadgets mentioned but not the shabu. 2. Under Article 1201, the choice shall produce no effect except from the time it has been communicated. For example, Viola binds herself to deliver a laptop or a mobile phone or an iPad to Rena, including all the accessories and accessions thereof. Viola communicated to Rena that she has chosen to deliver the mobile phone and its accessories. The selection then is irrevocable and the obligation has now become simple. 3. Under Article 1202, the debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. For example, Viola binds herself to deliver a laptop or a mobile phone or an iPad to Rena, including all the accessories and accessions thereof. Before she could choose, the laptop and iPad were both stolen. The obligation has become a sample obligation to deliver the mobile phone and its accessories. 4. Under Article 1203, if through the creditor's acts the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. Example, Viola binds herself to deliver a laptop or a mobile phone or an iPad to Rena, including all the accessories and accessions thereof. While Rena was inspecting the items, she negligently dropped the laptop and the iPad, destroying both. As a rule, since there is only one item viable, Viola can choose to deliver the mobile phone. However, since Rena was negligent, she is liable to Viola for damages for the damaged items. Article 1204 gives the instances for damages to arise when the debtor is at fault, and the basis of indemnity is the value of the last thing which disappeared or service which has become impossible. The creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed taking as a basis the value of the last thing which disappeared, or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. Article 1205 lays down the rules when the right of choice in alternative obligations is given to the creditor and the rules on loss of the objects. When the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be governed by the following rules. 1. If one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. 2. If the loss of one of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which, through the fault of the former, has disappeared, with a right to damages. 3. If all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any one of them, also with indemnity for damages. The same rules shall be applied to obligations to do or not to do in case one, some or all of the prestations should become impossible. Article 1206 provides that when only one prestation has been agreed upon, but the obliger may render another in substitution, the obligation is called facultative. The loss or deterioration of the thing intended as a substitute, through the negligence of the obliger, does not render him liable, but once the substitution has been made, the obliger is liable for the loss of the substitute on account of his delay, negligence, or fraud. This article talks about the legal effect of loss in a facultative obligation. A facultative obligation where only one prestation has been agreed upon, but the obliger may render another in substitution. The effects of loss will be applied, but based on which item was lost, either the original object or the substitute, and when the loss occurred, either before the substitution or afterwards. Article 1207 states that the concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render entire compliance with the prestation. There is a solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. The kinds of obligation as to number of parties are as follows. 1. Individual obligation where there is one debtor and one creditor. 2. Collective obligation where there are more than two parties, which can be further classified as either joint or solidary. A joint obligation is one where there are as many debts and credits as there are debtors and creditors. The whole obligation is divided proportionately and fulfilled proportionately between the debtors and demanded proportionately between the creditors. The following terms are indicative of joint obligation. Jointly, conjoint, or mancum or mancomunata, or mancomunitamente. Mancomunata simple, pro rata or proportionately, or ratio and proportion. Solidary obligation is one where each of the debtors is bound to render and each of the creditors can demand full compliance of the obligation. This kind of obligation is never presumed and must be clearly agreed upon unless the law itself states so. The following are some terms indicative of solidary obligation. Joint and several, jointly and severally, in solidum. Mancomunata solidaria, juntos y separatamente, individually and collectively, a promissory note worded as, I promise to pay, and signed by two or more debtors. Solidarity can be classified as follows. As to the parties bound, solidarity can be passive solidarity, which is solidarity on the part of the debtors, active solidarity, which is solidarity on the part of the creditors, and mixed solidarity, which is solidarity on the part of the debtors and solidarity on the part of the creditors. Solidarity can also be classified according to source as follows. 1. Conventional or voluntary solidarity, where the solidarity exists by reason of the agreement between the parties. 2. Legal solidarity, where the solidarity is imposed by law. 3. Real solidarity, which is once imposed by the nature of the obligation. Solidarity can also be classified according to the legal tie. Uniform solidarity is one where the parties are bound by the same terms and conditions. Non-uniform or varied solidarity is one where the parties are not bound by the same terms and conditions. Article 1208 states that, if from the law, or the nature or the wording of the obligations to which the preceding article refers the contrary does not appear, the credit or debt shall be presumed to be divided into as many shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. When the obligation is silent as to the nature of the rights and obligations of more than two parties in an obligation, the presumption is that it is joint, unless the law states otherwise. For example, under Article 1824, all partners are liable solidarily with the partnership for everything chargeable to the partnership under Articles 1822 and 1823. Solidarity is never presumed because it is very onerous or burdensome. Let us try to illustrate. If joint debtors A and B borrowed $20,000 from joint debtors C and D, how much can C collect from A? Answer: $5,000. If A is insolvent, can C and D collect the whole $20,000 from B? Answer: no, as B will only be liable for $5,000 to C and $5,000 to D. Remember that in joint obligations, the corresponding obligations of the debtors are prorated. The corresponding rights of the creditors are likewise prorated. There are as many debts and credits as there are debtors and creditors. Debtor A can only be made liable to C for the amount of $5,000, and to D another $5,000. In the same manner, B is liable to C for $5,000 and to D another $5,000. In effect, there are four distinct debts. Let us say that solidary debtors A and B borrowed $20,000 from solidary debtors C and D. How much can C collect from A? Answer: $20,000. If A is insolvent, can C and D collect the whole $20,000 from B? Answer: yes, as there is only one debt. Article 1209 states that, if the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the others shall not be liable for his share. This article is referring to a joint indivisible obligation where the nature of the rights and obligations of the parties is joint but the object is indivisible. An indivisible obligation is one which is not susceptible of partial performance, like the giving of things. The following are the characteristics of a joint indivisible obligation. 1. No joint creditor can act in representation of the other joint debtors or creditors, unless expressly authorized to do so. 2. No joint debtor can be compelled to fulfill the obligation of the other joint debtors or creditors. For example, in an obligation to deliver a car to A by two co-owners B and C, since the law or the agreement is silent as to the nature of the obligation of the two co-owners of the car, B and C, their obligation is joint. However, the object, which is a car, cannot be partially fulfilled. Article 1210 provides that the indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity of itself imply indivisibility. Indivisibility refers to the nature of the subject matter, while solidarity refers to the nature of the obligation of the parties, or the juridical tie. In indivisible obligations, only the debtor guilty of breach is liable, while in solidarity, all the debtors are liable. Indivisibility can exist even if there is only one debtor or creditor, while in solidarity, there must be at least two debtors or creditors. In indivisible obligations, the others are not liable in case of insolvency of one debtor, while in solidary obligations, the other debtors are liable. Article 1212 provides that each one of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. As such, a demand letter given by one solidary creditor to any of the solidary debtor benefits all the other solidary creditors. However, the waiver of the obligation by a solidary debtor is prejudicial to the other solidary creditors. Article 1213 provides that a solidary creditor cannot assign his rights without the consent of the others. Article 1214 provides that, as a general rule, the debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Article 1215 provides that novation, compensation, confusion or remission of the debt made by any of the solidary creditors or with any of the solidary debtors shall extinguish the obligation without prejudice to the provisions of Article 1219. The creditor who may have executed any of these acts, as well as he who collects the debt, shall be liable to the others for the share in the obligation corresponding to them. Novation, compensation, confusion or remission of debt are modes of extinguishing obligations. Article 1216 provides that the creditor may proceed against any one of the solidary debtors, or some, or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. Article 1217 provides that payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offered to pay, the creditor may choose which offer to accept. He who made the payment may claim from his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. Note that payment is a mode of extinguishing an obligation. Any solidary debtor who pays the creditor has a right to reimbursement from his co-debtors. The insolvency of any of the debtors will not prejudice the creditors, and such insolvency shall be borne proportionately by the other debtors. Article 1218 provides that payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. Take note that prescription is the period of time prescribed by law which, when it lapses, either a right is acquired or lost. Watch out for the video on prescription. Article 1219 states that the remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors in case the debt had been totally paid by any one of them before the remission was effected. From the moment any of the solidary debtors paid the obligation, he is entitled to the proportionate reimbursement from his co-debtors. Remission, which is another mode of extinguishing an obligation made by any creditor after such payment has been made, will not negate the right of the debtor who paid from collecting from his co-debtors. Article 1220 states that the remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. Remission or condonation is gratuitous. It means that the debt was forgiven and no collection was made, and, thus, does not entitle the solidary debtor who was extended such remission to any reimbursement from his co-debtors. Article 1221 states that if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. If there was fault on the part of any one of them, all shall be responsible to the creditor for the price and the payment of damages and interest, without prejudice to their action against the guilty or negligent debtor. If through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. Article 1222 provides that A solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him, or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof only as regards that part of the debt for which the latter are responsible. The defenses available to a solidary debtor are as follows. 1. Defenses can be based on those derived from the nature of the obligation, like payment, prescription, and other modes of extinguishing the obligation. All co-debtors can avail of these defenses. 2. Those that are personal in nature pertaining to the one debtor, like minority, insanity, fraud, mistake, or violence. These are total defenses, but only for that particular debtor. 3. Those that are personal only to the other debtors may only be availed of by the paying debtor as far as that part of the obligation pertaining to the other debtors. Article 1223 states that the divisibility or indivisibility of the things that are the object of obligations in which there is only one debtor and only one creditor does not alter or modify the provisions of Chapter 2 of this title. Let us look at some terms. Divisible obligations are those which have as their object a prestation which is susceptible of partial performance without the essence of the obligation being changed. On the other hand, indivisible obligations are those which have for their object a prestation which is not susceptible of partial performance. A thing is divisible when, if separated into parts, its essence is not changed or its value is not decreased disproportionately, because each of the parts into which it is divided are homogeneous and analogous to each as well as to the thing itself. A thing is indivisible when, if separated into parts, its essence is changed or its value decreased disproportionately. The following are various kinds of division. 1. Qualitative division, which is based on quality, not on number or quantity of the things which are the object of the obligation. For example, X, Y, and X inherited a house and lot, a car and shares of stock. They can agree to split the inheritance by object. That is, the house and lot will go to X, the car will go to Y, and the shares of stock will go to Z. 2. Quantitative division, which is based on quantity rather than on quality. For example, X, Y, and Z inherited a house and lot, a car, and shares of stock. They can agree to sell all the properties and divide the proceeds among them in equal shares. Third is ideal or intellectual division, which exists only in the minds of the parties. For example, X, Y, and Z inherited a house and lot. They agreed to keep the inheritance. They each own 1/3 of the house and lot. Each share is undetermined, and this is known as pro indiviso, or undivided share. What obligations are deemed divisible? Under Article 1225, Paragraph 2, it states that, when the obligation has for its object the execution of a certain number of days of work, the accomplishment of work by metrical units, or analogous things which by their nature are susceptible of partial performance, it shall be divisible. As to indivisibility, the following are its classifications. 1. Legal indivisibility, where a specific provision of law declares as indivisible obligations which, by their nature, are divisible. 2. Conventional indivisibility, where the will of the parties makes as indivisible obligations which, by their nature, are divisible. 3. Natural indivisibility, where the nature of the object or prestation does not admit of division. The following obligations are deemed indivisible. 1. Obligations to give definite things. For example, the obligation to deliver a laptop. 2. Those which are not susceptible of partial performance. For example, the obligation to deliver a 1-hour lecture. 3. Those provided by law as indivisible. 4. Even though the object or service may be physically divisible, an obligation is indivisible if so provided by law or intended by the parties. For example, and he agreed to pay the amount of 10,000 pesos to Lucia on January 15, 2021. While the money is divisible, the intention is one-time payment of the full amount. An obligation with a penal clause is one which contains an accessory undertaking to pay a previously stipulated indemnity in case of breach of the principal prestation, intended primarily to induce its fulfillment. A penal clause is an accessory undertaking attached to an obligation to assume greater liability in case of breach. Article 1226 states that, in obligations with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obliger refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provisions of this code. In an obligation with a penal clause, the accessory undertaking expands the obligation of the debtor. A principal obligation is one that can stand alone, and its validity or compliance is not dependent on any other obligation, like a loan. An accessory obligation is one which is dependent on another contract for its validity or compliance, like interest on a loan. What are the purposes of a penal clause? 1. To ensure performance of the principal obligation by the debtor, and 2. To provide for liquidated damages, and to enhance the coercive force of an obligation by the threat of greater responsibility. What are the kinds of penalty? As to origin, penalty can be as follows. Legal penalty, that which is provided by law. Conventional or voluntary penalty, that which is agreed upon by the parties. As to purpose, penalty can either be compensatory penalty, that which is established for the purpose of indemnifying the damages suffered by the obligee in case of breach of the obligation, or punitive penalty, that which is established for the purpose of punishing the obliger or debtor in case of breach of the obligation. As to effect, penalty can be subsidiary penalty, when only the penalty may be demanded in case of breach of obligation. Joint penalty, when the injured party may demand the enforcement of both the penalty and the principal obligation. As a general rule, the debtor cannot exempt himself from the performance of the obligation by paying the penalty. The exception is when this right is expressly granted to him. Proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. The courts may reduce the penalty if there were partial compliance. Under Article 1230, the nullity of the penal clause does not carry with it that of the principal obligation. The nullity of the principal obligation carries with it that of the penal clause. This is based on the principle that accessory follows the principal. Here are some points to ponder. 1. Is death always a period? 2. What is usufruct? 3. What are the rights of a usufructuary? 4. Is payment of a money debt an indivisible obligation? 5. What are the different prescriptive periods for various court actions? 6. Can an obligation not to do be divisible? 7. Does imposing a penalty make a debtor more compliant with his obligation? 8. As a student, knowing that if you do not study well, there is a greater chance that you will not pass this subject, does knowing such consequence make you study more? Thank you, and watch out for the next videos. Stay safe.